All right, I'll hear you, Mr.
Thank you, Your
Alessi.
Honor. May I go to the podium?
Yes.
Thank you.
Yell it out, Alessi. Yell at me!
So, just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolfe, confronted Dr. Wolfe with it as part of an accident reconstructionist cross-examination and challenging Dr. Wolfe on several aspects. And this one was particularly apt, the subject matter, not the manner of the examination, was, Dr. Wolfe, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And
yes,
our proposed curative instruction is on page 2 of our motion. It states, during the
yes, it's modest. No matter what he says is modest. I believe that this is grounds for mandamus, for an immediate order from a higher court heading down to direct the judge to offer a mistrial with prejudice or a mistrial without prejudice, one of those two. That's the only cure for this. This jury is irrevocably tainted by what Hank Brennan did. There's no way around it. So yes, anything that they demand less than that, which they demanded, in fairness, they demanded mistrial with prejudice, and Bev denied it. I think they should be filing for mandamus order on it immediately.
This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolfe had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue.
Alessi is stuck with a dilemma here. This should have ended the trial. It's that bad. It's that bad, and it was done intentionally. They even laid out that specifically the state never introduced the back of that hoodie. The entire trial, the state avoided talking about the back of that hoodie, and they brought it up at this specific moment so that there would have never been testimony about the back of the hoodie and where the cuts on the back of that hoodie came from. We do have testimony about where the cuts going down the front of the hoodie are and where the cuts are going up the sleeves because they had to remove the hoodie from him. But we only had testimony about those cuts being made by the resuscitative team. There was never testimony about the criminalist making those incisions at all. And so to avoid entirely talking about the cuts on the back of the hoodie is to infer that all the cuts on the hoodie were talked about by the by the witnesses brought forth by the state when they discussed, the removal of the clothing and why there's this extra and obvious damage to the hoodie itself. No one described why there would be those holes in the back, leaving a juror to the reasonable conclusion that those holes came as a result of an accident or whatever happened to Mr. O'Keefe. And the state knew this. The state is 100% aware of what they were doing. Brennan did it on purpose. And when he stands up and says, we made a mistake, the level of intentionality that goes through the entire case, all of it, you have to understand, they did this for 7 weeks on purpose. 7 weeks of deception leading to this moment. This case should be over. And Brennan should be potentially facing sanctions for it. That's how bad of a mistake this was. So Alessi is here trying to argue the ridiculous, that this can be cured by a jury. This is 7 weeks of intentional deception by the Commonwealth. Now, I don't think I've made enough of a point about this in the past. How bad this is, how horrifyingly unjust this is, how unfair it is, and to have Bev Cannone sit there in complicit compliance and encouragement for the state by not doing anything other than offering a limp-wristed, half-dicked curative instruction. Fuck her right in the face for exactly this. This is what should have her removed from the bench. It should have Hank Brennan sanctioned, and it should have Karen Reed walking out on a shopping spree right now with her boyfriend, Alan Jackson. Like, that's what should be going on. But no. No, instead we get this poor, I don't want to say poor argument. That's not what's going on. This poor position that Alessi is forced to fight from, where he is supposed to argue somehow that there is an instruction that is sufficient to cure the damage done. That in one line, 7 weeks of intentional misdirection, misconduct, and malicious malpractice has done. That some throwaway sentence from Bev Cannone is supposed to fix that.
The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been...
They could be going straight for mandamus, not just statements. They could be going for mandamus. They could be going for sanctions against Bev, and they're not. They'll wait till the ultimate outcome of the case and then just file an appeal if they lose. But I honestly believe that they should be asking for mandamus, because if they lose, the appeal's going to take forever, and Karen Reed will sit in prison. That's insane.
Things can happen. States can be recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to offer a...
Who cares if this is a mistake? Who cares? It doesn't matter that this was a mistake. This is an incurable mistake. Whether you call it intentional or a mistake is a matter for the sanctioning board, not a matter for the trial court. The trial court needs to only consider if this sufficiently prejudiced the defendant to the point where they cannot mount a fair defense. And that unequivocally happened. This is disgusting.
I don't think that there's any confusion by the jury, and furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay.
Unreal. They didn't get a curative instruction. They got a bogus statement from Bev Cannone that didn't address the issues at all. And there are other remedies, and mistrial is one of them, and you know it. But an explanation directly to the jury that, yeah, these cuts, like, you don't understand because I didn't say it properly before. These cuts were made by the state's criminologist. They could not have been made in any other way. They were not made in any way on the night of January 29th. They were made in May in a lab after this shirt sat on the ground or on the floor of a Jeep of one of the investigators. They were not made on the night of the incident in question. They cannot be considered in any way. And any inference that these cuts in the fabric came from either an impact with a car or anything else on the night of the 29th is impossible. We know for a fact exactly when these cuts were made. The state was unclear in how they presented this evidence before you. The state has made sufficient apologies outside of your presence, but we wanted to clarify these facts. The fact of this case, you do not have to find it, jury, because we know factually the state and the defense agree that these cuts happened in May and cannot be considered on the night of the incident. That's the kind of curative instruction that comes close to undoing the damage that was done, and anything short of that is not sufficient. Period, 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 period.